second panel. For this second session this morning, we welcome Professor Sarah Summers from the University of Zurich, Switzerland. Professor Sarah Summers specializes in evidence with special interest in criminal evidence. She published extensively in this domain and has a special interest in empirical studies. So her presentation today will be on evidential remedies for procedural rights or violations with comparative criminal evidence law and empirical research. So Sarah, the floor is yours.
Well, many thanks, Olivier. It's a pleasure to have you as chairing my session today. Many thanks, of course, to Jordi for inviting me to be here with you all. It's a great pleasure. I'm going to talk today about comparative evidence, so apologies at the outset to the civil procedural lawyers. I hope that I'll be able to pick up in the course of the presentation some of the points that I think Adrian Zuckerman was making in the very first presentation that we heard on Wednesday. When comparative issues of evidence are debated, they tend to revolve around this old debate about whether accusatorial or inquisitorial systems are better at finding the truth. So we see accusatorial systems are said to be flawed, the parties responsible for gathering, presenting the evidence are perhaps perceived as partisan, with the result that the sources might be said to be selective or even contaminated. The triers of fact are, meanwhile, forced to maintain a position of neutrality, unable to harness the context towards any kind of active inquiry, which would be required if they were to give any cognitive justice to the case. That's the sort of argument that you sometimes hear in inquisitorial systems against accusatorial procedural rules. So a highly regulated system of evidence for the admission of evidence at trial. The judge-driven procedures of continental criminal procedure are also said to be flawed in that they give rise to the risk that the trials of fact will form hypotheses too early. So although inquisitorial fact finders might have the freedom to mount their own inquiries, there's insufficient incentives for fact finders to generate a sufficiently strong evidential basis for making accurate judgments. So sometimes civil law systems are even portrayed in accusatorial systems as operating without any sort of rules of evidence at all. So this characterization of the rules of, or the law of evidence is obviously too narrow, and as John Jackson and I have argued in our book, obscures two important truths about any system of adjudication which subscribes to the importance of evidence and proof. So first, any system which gives triers of fact the task of evaluating evidence must subscribe to some doctrine of freedom of proof, and second, any adjudicative system must have some rules of evidence. But instead, this debate, this comparative evidence debate in particular, has degenerated into highly partisan views of the merits, essentially, of one system over the other system, and that's been unfortunate. At the same time, adherence to these idealised models of criminal procedure might also have been considered as contributing to the reluctance of supranational bodies responsible for regulating criminal procedure, and here I'm referring, of course, mainly to the European Court of Human Rights. The failure of these bodies to consider the importance of evidential rules in the context of regulating the fairness of criminal proceedings. It's not uncommon, of course, I'm sure a lot of you are familiar with the case law of the Court of Human Rights. It's not uncommon to find statements in the case law of the court to the effect that criminal evidence is essentially a matter for the contracting state. It's not something which is really a matter for the court itself. This is obviously nonsense. On one hand, Strasbourg in the case law is busy dictating the use of the evidence in all sorts of situations, from confrontation to torture. And on the other hand, it seems to espouse an understanding of the separation of the law of criminal evidence from criminal procedural law, which is, in my opinion, conceptually flawed. And in addition, this type of focus on inquisitorial systems in general might well distract attention from some other important issues which lie out with the debate. There's been little examination to my argument, there's little examination as to whether these two theoretical models that are often discussed actually reflect in any true sense the real-life actualities of the criminal procedural laws in the various jurisdictions. And I'm going to argue today that the consideration of criminal proceedings in practice is of essential importance to the comparative evidence debate. At the outset, I want to make it very clear, I'm not arguing that there are differences between the systems, of course there are. It's rather my position that these differences are not reflected in this typology that we're so used to hearing about. So I'm going to develop these arguments today by discussing the evidential consequences of violation of right to counsel in Swiss criminal proceedings, and I'll be discussing evidence which we collected in the course of a large empirical study of criminal trials in a number of Swiss jurisdictions. In the course of the study, a 6-person observation team spent 2 years observing criminal trials in the courts of Zurich, Geneva, Basel and Bern, and noting the manner in which fair trial rights were applied in practice, including the right to counsel, and noting how they were treated by the court, whether they were accepted, rejected, or simply ignored in day-to-day criminal proceedings. All in all, we observed a total of roughly 440 cases, roughly 100 in each jurisdiction. So my paper today won't essentially be comparative in scope. I hope, though, that it will be of interest to you in the sense that you'll be able to bring your knowledge of the legal systems to add, in some sense, the comparative element. So I'll give you some indication here right at the outset of the structure of my argument. I'm going to challenge the assumption that the Swiss system, which clearly falls within the continental European model, does not subscribe to evidential rules. I'll demonstrate that Swiss criminal procedural codes provides, if not for exclusion, then certainly for restrictions on the use of the evidence. And in this regard, I'm going to refer, by way of example, to the strong evidential remedies which exist to protect the right to counsel. And then I'm going to try and demonstrate how these strong remedies, how this strong right is undermined in practice. And I want to draw some attention to the relationship between de facto restrictions on procedural rights and the importance then of evidential remedies. And I hope that's going to provide the basis for a number of concluding thoughts. So before turning to the right to counsel, it's important to mention briefly in abstracto the nature of restrictions on the use of evidence in Swiss criminal proceedings. The use of evidence is regulated in 141 of the Swiss Federal Code of Criminal Procedure, and there are essentially 3 different rules which discuss the use of evidence which has been improperly obtained. We see in the first paragraph a mandatory exclusion of evidence in certain circumstances. Then in the second paragraph, a discretionary prohibition. The judge can't use the evidence unless. And then in the third paragraph, we see a provision which says all other evidence essentially can legitimately be used by the judge. So if we take a quick look at the first paragraph, the mandatory exclusion or non-mandatory prohibition of the use of the evidence, we can see that first, all evidence obtained by compulsion, use of force, threats, promises, deception, and so on, is prohibited from being used in criminal proceedings to convict the accused. In addition, we have a second type of mandatory prohibition on the use of the evidence. If that will be the case, if a provision of the procedural code expressly states that in this such a situation the evidence must not be used. And you can see I've got one example here of this type of provision in 158. According to this provision, evidence obtained at a hearing at which the accused was not informed of his or her rights, type of Miranda situation, this evidence cannot be used in any circumstances against the accused. So in these situations, principally the judge does not have discretion. Then turning very briefly to the discretionary prohibition, there's an important rule governing the discretionary prohibition on the use of evidence. In this sense, evidence obtained in violation of rules protecting the validity of the evidence. And of course, there's discussion about what these types of rules might be. Rules which are solely, according to the court, or principally, which principally serve the protection of the accused, is one definition. Then, in this situation, the evidence can't be used unless, and here we see another proviso, unless the evidence is essential for the purposes of solving a serious criminal case. So here we can see there's obviously considerable room for interpretation. The judiciary have had to determine what constitutes a serious offence, what essentially essential might mean in this context, as well as which provisions of the code can be understood as protecting the validity of the evidence. In addition, then, in the individual case, the judge has considerable discretion in determining whether these tests are met or not. Before going on, it's important perhaps to think very briefly about the nature of 141. Can't probably be characterised strictly as an exclusionary rule if we understand exclusionary rules as operating only within a system of admissibility, as in the case in common law systems. In the common law context, the bifurcation of proceedings means that the judge will determine the admissibility of evidence and ultimately, if necessary, exclude the evidence. This means that the fact finder, the jury, in many cases, won't actually hear this evidence. And that's, of course, an important difference from systems such as the Swiss system, which do not separate the tasks of fact-finding and judging. And here, though, we can question to what extent a person who has heard the evidence is really able to exclude it from their decision-making process. And there's been a lot of important studies on this issue. I'm sure everyone knows those conducted by the famous German Schünemann and so on. And I think it's very important to note this is an important issue, but we should be careful not to overestimate its relevance. Many common law trials, of course, are heard without a jury. Professor Cheryl Thomas is estimating in the context of England and Wales that just 1% of all criminal cases are heard by a jury. We heard yesterday from Ho Hai Lok that in Singapore there's no jury. In this type of case, then, of course, the judge, just like a Swiss judge, is making decisions on use of the evidence and later on acting as the finder of fact. So how are these remedies applied in practice? What relevance does the remedy have for the extent of the protection of the specific procedural provisions or right? And I'd like to illustrate my argument today by looking at violations of the right to counsel in Swiss law, the available remedies. I want to speculate a little about the impact of the remedies on the extent of the right. And I'm going to try and use the data that we've collected in our study to demonstrate that even if there's complete acceptance of the importance of a procedural rule, weak enforcement on the evidential level has the potential to materially interfere with the exercise of the right. So the right to counsel is acknowledged across Europe, of course, to be a crucial aspect of the right to be heard, of the right to a fair trial. We've had groundbreaking judgments in the last decade from the Court of Human Rights, cases such as Saduts, Pishalnikov, and there can be little doubt that, in theory at least, the right to counsel has been taken very seriously. We might assume the accused will be aware of the rights and be happy to make use of the rights in the criminal proceedings. We might also assume that those involved in the proceedings are actively involved in ensuring that the accused is able to exercise these rights. So I want to begin by looking at some dialogue from a trial in the Swiss city of Bern, a beautiful city. I'd just like to emphasize that before I go on to criticize strongly their procedural provisions. The accused was on trial for fraud, falsification of documents. The prosecutor requested a sentence of imprisonment of 12 months. The accused's German was pretty poor, as is par for the course in many Swiss criminal trials. about 45% of the accused are not Swiss. And the observer recorded the following dialogue. So the judge said, "You have the right to a lawyer if you want one. You'd better tell us now and we'll adjourn the proceedings." It's perhaps interesting to note at this point the judge had already questioned a witness in the proceedings. And the accused replied, "Well, I don't have money for a lawyer." To which the judge said, "Well, should we just proceed without a lawyer?" And the accused said, "Yes." And then the judge, perhaps having a second thought, said, "Well, you know, there is the option of a legal aid lawyer, but in this case we'd have to rule on whether you'd be entitled to it or not. You might have to pay these lawyers' costs at a later stage in the proceedings." To which the accused replied, "I don't think I need a lawyer." And the judge said, "Well, I don't think so either." And the case proceeded to trial. The accused was subsequently convicted to a financial penalty of 180 daily units, so perhaps not a hugely serious case, but nevertheless was sentenced to nonetheless. I want to say here at the outset, this case is in some sense hugely exceptional because assistance to counsel in Switzerland at trial is very much the norm. If we look at the provisions in the code, we can see in 129, the accused is entitled to counsel at any point in the proceedings, at any time and at any stage in the proceedings. And this strong level of protection afforded in the Procedural Code is also reflected in high levels of representation in practice. So if we look at the data from the project, we can see in roughly 90% of cases across the 4 different jurisdictions, the accused was in fact represented by counsel at trial. In line with most European criminal justice systems, only about 5% of cases actually go to trial. But of these cases, high levels of legal representation. In addition, and this contrasts sharply with what we heard on Wednesday, legal aid is readily available in Switzerland. We can see first in the code, legal aid shall be granted if the accused does not have sufficient funds and a defence counsel is necessary to safeguard his or her interests. And here it's important to state criminal lawyers in Switzerland and Zurich bill by the hour. The hourly rate, 250 francs in Zurich, while not high, is certainly reasonable and certainly considerably higher than in most European jurisdictions and worlds apart from the position in England, Wales and Scotland. Strong right to legal aid is mirrored in practice by high levels of legal aid representation. If I just shoot through the statistics, we can see that in around 60% of all cases, the accused had legal aid counsel. And if we stream by seriousness, we can see that in more than 95% of cases in which the prosecutor requested a sentence of more than 1 year, the accused had a legal aid counsel at trial. Finally, we might want to think about how often the right to counsel is complained of at trial. In the context of the study, we monitored how often a defence counsel or the accused were complaining that their rights had been violated in the course of the proceedings. In the context of, we can see number 8, right to counsel. Defence, the issue of the right to counsel was raised in just 14 cases of 440, that's roughly 3%. The other figure below is the number of violations potentially observed in the course of the proceedings. So we see the number of potential violations are much higher at 50. So the conclusion might be here, well, you know, if you want a counsel, you'll get it. And this looks, we might be forgiven for thinking, well, the right to counsel is employed in exemplary fashion in Switzerland. But during the study, we did uncover some problems with enforcement of the right to counsel. And the most important of these concerned delay. And the conclusion of the proceedings, we asked the accused and a defence counsel at what point in the proceedings they become involved in the case. And bearing in mind, of course, that perhaps that's important to say that in Switzerland, much of the proceedings, much of the contestation of the evidence happens in the pre-trial, not at trial, so it's very important to be involved in the case early. Although in our study, 90% of the accused persons were represented by counsel, in something like 65 to 60%, 68% of cases, there was delay in access to counsel in the sense that the counsel was not participating in the first hearings with the police and the prosecution. So we see that although there's a strong right in theory to counsel from the very beginning of the proceedings, this is not mirrored by the situation in practice. And here you might think, well, just to underscore perhaps the importance of all this, in a large number of cases, the judge relied in the oral reasoning for the conviction on statements made during the investigation phase. So that suggests that despite the existence of strong procedural rules, the courts routinely rely on statements made before the accused had received the assistance of counsel. And so, as I mentioned earlier, in only a small number of cases did the accused or defence counsel complain about a right to counsel at trial. So we might think, well, how can that be? Why on the one hand do we have a low number of complaints about exercise of the right to counsel in practice, and at the same time such high numbers of essentially serious interference with the right at an early stage in the proceedings? Why this disconnect, if you like, between the exercise of the right and complaints about interferences with the right at trial? I think it's safe to say that one of the main reasons for this is the fact that even if you complain about the exercise of the right to counsel at trial, there'll be very little impact, in the sense that it's unlikely to result in a restriction on the use of the evidence. And so why might that be? It's important to think about the reasons for delay in the first place. If we consider the earlier example from the trial in Byrne, we can see that the accused was clearly informed of the right to counsel. It wasn't the fact that he hadn't known about the right to counsel, but was worried about the costs. We saw this in a number of other occasions. I'll just take some dialogue from another case from Basel. The judge said to the accused, "Have you read the indictment? Do you understand the case brought by the prosecutor?" And the accused said, "Well, no, I couldn't afford a lawyer." And the judge said, "Well, you know, you have the right to a legal aid lawyer. In your case, it's very likely that you would have fulfilled the criteria to be entitled to legal aid." And the accused said, "Well, I did ask, but they told me that I'd have to pay for the first meeting with the lawyer myself, and 280 francs was just too much. Would a lawyer have been useful?" To which the judge replied, "Well, it wouldn't have done any harm, but I'll consider both the facts that speak for you and those that speak against you." So I have to say that at this point I feel almost a moral obligation to send this judge to Adrian Zuckerman for lunch in London so that you can explain to them the importance of the separation of functions and the confirmation bias. But we'll see. So here we can see again the accused was motivated in rejecting the assistance of counsel by even having to pay for 1 hour of legal advice. We also asked accused persons at the completion of the trial why they hadn't insisted on counsel earlier. Common replies included that they weren't aware of the right to legal aid, they were worried about having to repay costs. So if we turn to look at then the evidential implications of this sort of scenario, we can turn again to 158. So here the accused is to be informed at the beginning of the proceedings about his right. Strong evidential remedies exist to protect the rights of the accused. Failure to inform the accused of the right, as mentioned earlier, will result in a mandatory prohibition on the use of the evidence. But here's the problem: it will seldom be the case that the police or prosecution will entirely fail to inform the accused of his right to counsel. And in fact, in light of standardised protocols and so on, it's fair to say, I think, that this type of situation actually doesn't even exist anymore in practice in Switzerland. It will never be the case that the accused is not informed of the right to counsel. Less dramatic scenarios, if you like, are of relevance here. In the cases that we encountered, the problem was not so much then a total lack of information about the right to counsel, but rather that the information on the right was incomplete. So the accused was informed about the right to counsel, but not informed about the legal aid entitlement. Or they were informed of the right to counsel, but this information was immediately qualified by statements that the accused might have to repay the cost of the proceedings, also that lawyers are expensive, maybe not necessary, that we could just maybe conduct a first hearing, and then after we've conducted this first hearing, the police officer would be able to, or the prosecutor would be able to tell the accused if it was really necessary in his or her case to have counsel. So for us, the interesting question is what sort of remedy, what sort of evidential remedy would be available if you're informed about the right but not about the legal aid entitlement. Well, in these cases, first off, we've got the problem of waiver. The accused will be assumed to have waived the right, and to cross the waiver hurdle, will have to prove that the waiver was invalid. It's obviously going to be difficult to prove that the information provided by the police or prosecutor, that they actively sought to dissuade them from taking counsel. But even assuming that the accused was able to cross this hurdle, what are the evidential consequences of an incomplete caution? The question is whether the right to be informed of legal aid is an independent aspect of 158 paragraph 1. If so, there would be an absolute mandatory provision on the use of the evidence, but it will come, I'm sure, as no surprise to any of you that this is not the way in which it's been interpreted. Here, it's assumed that the evidential prohibition refers to cases in which the accused was not informed at all about the right to counsel. And all other situations will give rise at most to discretionary prohibition on the use of the evidence. Similarly, if the police or prosecutor informs the accused of the right to counsel, but immediately qualifies that to try and dissuade them from taking counsel at an early stage, then this will give rise at the most to discretionary prohibition on the rules of evidence. 158.2 wouldn't be relevant at all. And then again, as I mentioned earlier, in all these cases there's considerable judicial discretion on whether the evidence can be used, whether it was obtained in violation of one of these Gültigkeitsvorschriften, rules protecting the validity of the evidence, whether the charge concerned a serious crime. Here the court has considerable discretion. It's certainly the case that as soon as a more serious case is at issue, it's extremely likely that the court will feel able to make use of the evidence in line with the provisions in 141.2. So just to summarise here then, we have a strong right to counsel, and in spite of this, the police and the prosecution can caution the way in such a way as to ensure that they manage to dissuade the accused from immediately insisting on the assistance of counsel without really having to fear that this will have any impact on the subsequent use of the evidence at trial. So here we can see in a way that these weak evidential remedies have the potential to impact on the scope, on the extent of the right to counsel. So looking at this, what does this all mean? What does this all tell us about the nature of the system? What's the relevance of all this for comparative criminal evidence? Well, first, I think a system can compensate, and I think that is very clear, a system can compensate for strong procedural rights by restricting the extent of evidential remedies. And here we can see quite clearly the potential for the criminal procedure system to compensate for these rights by restricting the availability of strong remedies such as mandatory prohibitions on the use of evidence at trial. And here we can see that concerns, and these were very evident in Switzerland before the law was changed post-Saldo. Here we can see the concerns that the right of the accused to take counsel early might hinder the investigating potential of the prosecution and the police, have been solved in such a way as to ensure that the interests of the effective investigation are not compromised by restricting essentially de facto the rights of the accused. So in order to protect the effective investigation, the system allows for de facto restrictions on the right, coupled with this weak discretionary evidential rules, while paying lip service to the importance of the rights of the accused. And here I think it's quite important to think in the context, particularly in the EU context, the European context, that simply strengthening defence rights, such as by way of this written letter of rights and so on, may in fact prove counterproductive without or in the absence of appropriate other regulation. So in the context of the letter of rights, the accused is signing a cast iron waiver in the majority of cases, thereby limiting the possibility for complaining about the use of this evidence at a later stage. And in this context, I think it's very important that we give some consideration to the arguments of, or the dissenting opinion of Lord Kerr at the UK Supreme Court, that a waiver should only be valid in such cases after the accused has been able to take legal advice on the waiver itself at an early stage in the proceedings. So this gives rise to clear questions of legitimacy. Are strong procedural rights dependent on de facto restrictions on the exercise for their existence and acceptance? Second, I think these examples demonstrate the importance of evidential remedies for uniform application of procedural rights. So if we accept the nature of evidential remedies impact on the scope of defence rights, on the scope of procedural rights, then this seems to call very much into question the idea that procedural rights can be applied uniformly in different procedural environments in the absence of regulation of evidential remedies. So in other words, if the aim is to ensure uniform application of procedural rights, there'll have to also be regulation of evidential remedies. Third, this debate on exclusionary versus free proof principles within the context of this accusatorial inquisitorial typology seems to be of very little relevance in the context. Switzerland clearly has exclusionary type rules, or if you want to call it that. At the end of the day, the interesting issue is to what extent procedural rules should be protected by red line rules, mandatory prohibitions on the one hand, and in which cases it's legitimate to allow some judicial discretion, if you like, in determining which evidence can be used and according to which criteria. So seriousness, harm doctrine, or whatever, in the different proportionality depending on the various jurisdictions. Switzerland, as part of the continental tradition, might be understood as being governed by the free evaluation of evidence, but we can see from my example that the reality is much more complex. The judge is, of course, bound by rules of evidence, and the question is the extent of the discretion, and not the factors and the various factors impacting on the decision. I would also imagine that the type of scenario that I've mentioned here, this on the one hand granting strong procedural rights, on the other hand compensating in some sense in the course of the system to ensure that the other interests are, such as the interests of effective investigation, are nevertheless not compromised too much. These are very common to many jurisdictions, and I think it would be important to look more at how these operate in practice. It might well be the case as well, again in the context of comparative evidence, that other lines are being drawn. They might have to think, on the one hand, about the importance of judicial discretion, which is being played up very much in the case of the European Court of Human Rights. The judge is the ultimate guardian of fairness in many of the cases, on the one hand, and we see these provisions being introduced into many of the European procedural codes, also into the procedural code in England and Wales, where we have discretionary ability of the judge to exclude evidence if it's not fair. This is the type of rule which is very much propagated by the Court of Human Rights. And compare that with let's say, the US system, where there still remains considerable mistrust then of the judge, at least in the criminal context. So finally, my last point perhaps, these findings highlight, I think, for me, the importance of paying attention to the real life practices in the context of comparative evidence. We need to engage more with the realities of criminal proceedings and about the ways in which rules of evidence and procedure operate. And we need to ensure that these issues are also considered in the context of this discussion. Many thanks indeed for your attention.
Buenísimo.
Perfecto. Entonces, por favor.
Sí, se ha reparado todo, perdón por opacar la...
Sorry, there was a technical problem here. Thank you very much, Professor Summers. I think that your research is an excellent one, very illustrating. And in particular, I have 2 points that I would like to mention. The first of all has to have with the right to counsel and this kind of asymmetry existing in the civil procedure. The right to counsel, there we have the idea that it cannot be a line of research possible. The fact that the right to enforce the right to counsel is used in previous measures, not when the accused is arrested, and not in the trial either when the person is informed about his or her right. But when we talk about civic education, education as fundamental rights, and maybe if we could specify what law means and how law is applied. But I'm talking there about legal education, civic education. Why am I saying that? Because when we are in a trial, when someone is arrested, there are certain restraints because of the time that might be that the accused thinks it's not so important to have a defense, to have counsel. And then a second question concerning the second part of your speech about the discretion of the jury when admitting or excluding evidence. Because when these kind of studies are made that show and reflect this asymmetry between the parties, and usually there is a social, cultural, or economic asymmetry, we need to see that this asymmetry is just a reproduction, a translation of another symmetry that exists beforehand. In many cases, the parties of a contract are unbalanced, and if there is a litigation, that asymmetry will be shown before negotiation, when we are talking about procedural rights. Therefore, we could say, well, the judge could be freer in order to establish a balance or strike a balance between the parties. But the problem to give more freedom to the judge is the fact that there will be a kind of judiciary activism or probatory activism, evidential activism, which will be more restrained, more limited. But in the same way, there will be an impact. So what's your opinion according to this phenomenon? I mean, maybe there might be a good motivation, but all in all, there can be a problem at the end.
Is it okay? Okay, thank you. Then we have a second question here. Yes? And then the third, Giovanni.
Bien, muchas gracias, profesora, por la presentación.
Thank you very much, Professor, for your presentation. I thought it was really very interesting, especially because you talk about the illicit evidence and the foundation for the evidence being admitted or not admitted. You never said it in those terms or words, but in the jurisprudence there are many comments about illicit evidence. At the end, there is an effect. I mean, when the institution is applied, whatever the name we use, and therefore there are exclusions that can be in the hands of the judge or of the public ministry. So, what's your opinion? And I know that you are talking about the right to counsel, but a right to counsel which is part of the right to evidence, which is an important right within the criminal procedure, but also in general. Thank you.
And then the third question here, Giovanni. Please raise your hand. Okay.
Thank you. Just a clarification question on the notion of the validity of evidence you are mentioning. I was wondering if they refer to scientific validity, for instance, as the US Supreme Court does in the Daubert decision, where they discuss the notion of, scientific validity, so the validity of scientific evidence, or if they just use some legal concept of validity in that.
Yeah, so I think it would be wonderful if they would refer to some sort of scientific concept of validity, but it's very, very blurry. It's I would even hesitate to call it particularly legal in that context. So it's a very case-by-case approach to trying to determine what type of provisions might even fall within this term good gets for. So, yeah. Oh, no, sorry, I thought that was just a point of clarification. Okay, so, and then on the first question, so I wasn't sure if I really understood you
correctly, were you, if you were suggesting legal education instead of counsel or in addition to counsel? So if you're legal, the idea of having legal education as an alternative to counsel, I think, would be not sufficient because of the structural imbalances in the proceedings. So the idea is that you would have, in addition, more legal education might be useful, but again, would certainly not provide any sort of substitute, I would say, for assistance of counsel in the context. And I think that's very important in this type of context, particularly the system which is being designed by the Strasbourg Court is very much dependent on an adversarial understanding of trials as a tripartite conception, if you like, with an impartial judge, two parties, and that implies then that there has to be a legal assistance in some sense of one of the parties. I don't think that would be, although of course it would be perhaps a good idea to have more information to educate people better. On asymmetry, I think asymmetry recognition, I wasn't too sure if I understood correctly from what really was being said, but judicial freedom, perhaps that goes also to the next question, differences between mandatory and discretionary, exclusion of evidence by the judge. These are different questions, but I think it's really goes to the heart, in some sense, of procedural rights. So we make some decision about, well, what is it that we're trying to protect? And if we really wanted to protect these things, then we should go all out. And I'm not saying that there has to be, in every case of unlawful collection or obtaining of evidence, there has to be an automatic prohibition on the use of the evidence. But we have to decide where the borders are and which rights are being affected. And I think this is absolutely central. This is definitely what's lacking in the case law of the European Court of Human Rights. It might be.
Thank you. So, yes, Adrian's
I'd like to ask a question about methodology. What is really interesting about this research is that it brings us closer to what actually happened. We have heard a lot about the theories of reasoning and how judges do or should be doing justice, how they should draw inferences and so on. And I was wondering, what was the methodology? Did the methodology involve interviews with judges, or was it just an examination of records?
So it was the project was essentially, am I allowed to take this question?
Yes, please.
Was essentially first an observational study of criminal trials. So we had an observation protocol, and the team members went to the trials, randomly selected from the case lists which were published in advance, and filled out the observational protocols for each of the things, and we entered this into this web-based database. In addition, at the end of the proceedings, we conducted interviews with the prosecution, defense, and the accused, but not with the judge. On the basis that it would be a bit strange to be discussing with the judge whether he or she thought the trial was fair. And as the whole study was about the fairness of the judge was hardly going to say, well, his trial wasn't fair. So in that sense, we thought it would be better to avoid questioning the judge, although it might have been interesting, actually. It's a shame we didn't do that.
Is there a way to investigate how judges actually reason? My question is there, in principle, whether there is a way in investigating how judges actually reason, and what help the theories that we are discussing today, or have been discussing in the last few days, might be of help?
Yeah, I think there is some empirical work on judicial reasoning, but as you suggested in your question, very much in the context of interviews then with judges and trying to pinpoint the ways in which they reason and the reasons for choosing certain ways. But, yeah.
Okay, now we have a question here. Please raise your hand so that's okay. Thank you.
Buenos días, mi nombre es Rocío de Perú.
Good morning. My name is Rocío. I come from Peru. And I have a question here concerning a statement that you made in your presentation. You talk about the impact of the use of evidence when there is no defense, no lawyer for the defense. I would like to know which is the impact of the use of the evidence concluded in the research, or whether there has been any kind of survey or study, maybe not in this research, but maybe in another kind of study or research in the country. Thank you.
Yeah, so in the context of our very limited research, then when we talked about the impact, we were looking about whether the judge relied on the evidence in question for the oral reasoning and the verdict, because that's all we were privy to in the course of the proceedings, just the oral reasoning for the verdict. Whether the judge decided not to rely on the evidence or not expressly. More broadly on the impact, well, I think I'm sure that it would be important to do more studies on that. I think there are some studies in England and Wales, but not very many, because this type of study is very expensive and it's difficult to secure funding to have people going to court and record what's happening. One option is, of course, to look at reported judgments, but that makes it all very difficult because most of these issues are happening at first instance. A lot of first instance judgments aren't reported, and that makes it very difficult to conduct empirical research in any other way than actually being in court.
Thank you. Yes, please. Yeah. Is there anyone else? Yes, please.
Good morning. Thank you for the lecture and the text. As I understood from the text and the lecture, there's a situation in which the more serious the crime is, the more probable it is for the judge to balance the rights and not to be a mandatory exclusion of rule, but a discretionary exclusion of rule. And I had the impression that this is a diagnosis of what's happening in the country. I would like to know if there is also a prognosis, I mean, going through some plans of changing the legislation, because you found here, at my feelings, a problem with this legislation, the legislation in Switzerland. And I wonder if this project would encourage you to go towards change this legislation. I mean, what should be exclusionary rule? What should be a mandatory of not using an evidence does not depend on if a crime is serious or not serious, or as we heard yesterday, the more serious the crime is, the more cautious must be the judge in admitting the proof. And not this perception here that the more serious a crime is, the more flexible is the way that judges will admit or not admit the evidence.
So I think you're right. It is a problem. I think I would say looking at, and of course many people have written about this. Professor Ashworth has written at length about the use of reference to seriousness in the context of criminal offences. I think that's a dead end. I think looking at the seriousness of the offence is not a particularly helpful way of deciding whether or not to use the evidence or not. So I would reject that. And the Swiss approach, whether my work would lead to any sort of law reform, probably not. This was cemented. This approach was based on the jurisprudence of the Federal Supreme Court, which was cemented in law by the recent coming into force of the new Swiss Federal Code of Criminal Procedure in 2011. So it's relatively new, our procedural code, but this is based on 50 years of Federal Supreme Court case law, that this is the way for deciding basically a large presumption in favour of the use of the evidence. So do I think that my research would... Well, I've tried. I've published a lot of articles in German and French, but I'm sure they think it's just that strange Scottish common lawyer with her weird idea. So yeah, I'm rather sceptical about whether there'll be much change.
Thank you. Yes.
Gracias. Buenos días. Soy Aleksandra de México.
Thank you. My name is Aleksandra. I come from Mexico, and I have a question related to something that you said during your presentation about the exclusion of the illicit evidence, that the judge can exclude this evidence when he believes that there is an unfair evidence. So when can this exclusion take place, please? And not only because it's illicit or because there is a transgression of fundamental rights, but when the judge thinks it's unfair.
Well, I suppose that here there's two different issues that it's important to separate. So first, in the procedural code, as you saw in my presentation, there's no mention of fairness in relation to 141 in this provision, which is responsible for non-use of the evidence. But when determining, of course, whether the provisions of the code are designed, or gültighetsvorschriften are designed to protect the validity of the evidence, and looking at whether they impact on the rights of the accused, then fairness in the sense of Article 6 of the ECHR becomes very important. So in the context of this test, the judge has quite a lot of discretion. So this is where the fairness aspect comes in, perhaps in a loose sense of talking about the right to be heard. Generally, the right to be heard would all be discussed within the context of whether procedural provision can be determined to be a rule protecting the validity of the evidence. But then, of course, even in serious cases, even if it is a rule protecting the validity of the evidence, the judge is permitted to use the evidence, to rely on the evidence in convicting the accused. And then, unless there are other provisions, such as perhaps in the case law of the ECHR, which would prohibit that. But as the ECHR is very reticent in claiming any role in regulating the law of evidence, then that makes it very difficult for defense counsel.
Yes, please.
Hola. Mi pregunta va vinculada con las consecuencias.
I have a question related to the consequences that you identified, the consequences of the lack of having a lawyer in criminal cases. I was wondering whether you see that there is an impact when there is no evidence, or I mean, in what happens when the person is defending herself or himself? And then I would like to know whether there is a more active role on the side of the judge in the cases in which there is no defense lawyer. For instance, in the case that you mentioned in your presentation, in which the judge said that he was going to consider the evidence in favor and also against. So can you identify this behavior and have the judges been active in these cases in which there has been defense or not defense, counsel or not counsel? And finally, I would like to know, what do you really understand when you say legal aid? I mean, what does legal aid mean? What are the implications of a person having access to legal aid? Is it an aid that is completely free? Do they really have, the defendants have to pay something? Can you elaborate a little bit more on what legal aid means? Thank you.
So yes, first on the issue of the role of the judge in the proceedings, that's generally quite interesting, and we tried to look at this as well in the context, particularly of judicial impartiality. So in cases, I think it's also important to mention that in many cases the prosecutor doesn't appear at trial in Switzerland. Only in cases in which the prosecutor asks for a sentence of more than a year is the prosecutor actually present at the trial hearing. So in many cases, there'll be no prosecutor at trial, and in some cases then no defense counsel. So in some cases the judge will just be there with the accused. And that was the case in the two cases that I mentioned here. Both were cases which concerned a prosecution requesting a sentence of less than a year. So we had to look to see, I mean, you might expect that, I don't know if you're familiar with the judgment, the case of the European Court for Human Rights in 6.1. There the court has said, actually, the prosecutor has to be present, because if the prosecutor isn't present and the defence counsel is present, there's a danger, and I think this goes to perhaps what Adrian was also mentioning on Wednesday. There's very much a danger that the judge might be forced into the role of, well, if in the absence of the prosecutor, into the role of the prosecutor. Or alternatively, if defence counsel is present, the prosecutor would be present perhaps into the role of defence counsel, but this type of situation doesn't arise. So I think that's a real danger, and we tried to look to see what was happening in these cases, and we didn't manage to find any statistical, particular statistical interesting correlation between judicial activity and the presence of, or absence of, either the prosecutor or defence counsel, which is not to say that it doesn't exist, just that in the context of our study, perhaps we didn't have enough data to look at that in much detail, but that's certainly a huge concern, I would say. And I would argue that it's ridiculous to have proceedings where there's a judge and no prosecutor at trial, but that's just me. On the issue of legal aid, specifically, I mean, legal aid means that your lawyer will be paid by the state, you won't have to pay for the costs. On the issue of repaying the cost, it's possible that you might have to repay the cost, but that's also within the discretion of the judge. So the judge will make a ruling on whether the legal aid costs should be waived at the end of the trial. So it could be that you're convicted and you don't have to pay the costs of the lawyer. It might be that the judge decides that you do have to pay the cost of the lawyer. It's difficult to have too much certainty on that point, but only if you're earning. It's a bit like a student grant in the United Kingdom. You've got to be earning a certain much before you're obliged to repay the cost of the loan. And it's important to mention in this context too, that the cost of the lawyer are actually quite a small percentage of the costs which the accused will have to repay in the event that they're convicted, because the costs of the proceedings, as you can imagine, in Switzerland are very high. So it's routine for the cost of the proceedings to be in the region of 50, 70,000, 80,000 francs, even in a relatively minor case. So whether the accused, in addition, has to repay the legal aid costs is perhaps just one aspect of that.
Thank you.
¿Qué tal? Gracias, maestra, por la exposición.
Thank you very much for your presentation. My question has to do with the impact of the lack of counsel and I would like to know what happens when there has not been a counsel, whether this has had a consequence, and whether when a sentence has been established, the sentence can be reopened in the light of that lack of counsel.
So that would be the sort of case where there would be a finding at a later stage that the right to counsel had been violated. Is that the sort of situation, and what the impact then, whether there would be a possibility to have the case reopened? Is that the question? Yeah, so this, in theory, that would be possible if you can prove that the denial of right to counsel was so serious as to impact on your right to a fair trial. So that would be a possibility, a violation of, that would be a possibility, a procedural possibility. But the problem is that that will virtually never happen in practice because of the type of situation that I was discussing here. There's so much discretion for the judge in determining these discretionary prohibitions in the use of the evidence that it would be difficult to find this sort of situation in reality. So that's why there's virtually no, I think there are no cases like that. Although it would be a theoretical possibility, there are no cases like that in practice.
One question here.
Gracias, profesora. Yo quisiera que...
Thank you, Professor. I would like you, if you remember in those cases you did research on, what were the offenses? What were the offenses that were put in front of the judge? In the cases that you did research on.
So generally we looked at all offences, apart from the minor the minor case. So all Verbrechen und Vergehen. So that's everything which could result in a prison sentence. And so it was we weren't allowed to select for severity in that sense, according to our own statistical methodology. Everything really ranging from murder to fraud to drugs offences. Bear in mind that most of a lot of crimes are already disposed of in earlier procedural mechanisms, the summary penal orders, proceedings, and so on. We didn't look at anything happening on that level. So, in the two examples that I mentioned here, one was a fraud case, and the other was I'm not sure actually what the other one was. I'd have to double check, but yeah, a range of different offences.
Okay, any question? So maybe if there's no question here, I might use as a chair, the possibility to raise a question for you. And I would like to maybe, because in the presentation you gave, of course, there's the possibility to relate your findings with the broader question of the access to rights outside the scope of the judiciary. And in those domains, there's a huge literature showing that people won't use the rights they are granted for lots of reasons, not only for loss of information or lack of information, but for a reason including family settings, budgetary settings, of course, but also their inclusion in networks of people or their participation into whether they have a job, whether they don't have, whether they are enlisted, they are members of an NGO, of a trade union. All those kind of parameters intervene in the access to rights. So my question would be, as you had interviews with people in courts, could you investigate the other dimensions outside the cost, of course, of access to rights, access to counsel, that could intervene in the fact that they, at the end of the day, didn't have a counsel? And this would have an implication in maybe the more prescriptive dimension of your work, because it might occur that the policy that could be developed as an answer to your findings might not be only related to the functioning of the courts, but also might include campaigns in other settings than courts, especially in NGOs or trade unions or even at work. So my question to sum up this is what kind of information could you get from qualitative interviews, and how does it give you a better view of the situation of those people in the situations, with a large view of those situations in which people don't get a counsel?
Yeah, so we didn't have too much potential to talk in depth with the accused persons, and part of the reasons for that was we established very early on in our pilot project. We ran a short pilot project before we started on the study. Was that at least 50% of the accused persons in Switzerland don't speak the language of the court, so German or French, depending on where we were, and that made it very difficult, obviously, to ask any sort of questions which would be. We're very much interested in being able to compare our responses. So we had to very much restrict the number of questions or the type of questions we were asking, because we had to have everything translated into 15 languages, because we couldn't have an interpreter with us in I don't know, all the various languages of the accused people in Switzerland. So we had a very standardized form of questions. So we were interested particularly in linguistic ability. Mm-hmm. So that's something that we might be able to test for the impact of that. But beyond that, gender, age, linguistic ability, beyond that, not very much else. Mm-hmm. Yeah. But it would be very interesting for us.
Okay, thank you.
Then we
Excuse
can
me?
take a break. I think we can take a break now. Yeah, I think, or what time is the next one?
Yeah, it's... Okay, so no frustration. So,
There's one guy.
okay, there's one question. You point me to... Okay, sorry, I didn't saw your sign. So please.
Working out. Professor Sarah, thank you for your exposition. It's one more question about methodology. You say that at the beginning, in comparative research, it's better to consider concrete data, how criminal procedure has been managed in particular reality, rather than considering ideal types or abstract models of legal procedure. Don't you think these two approaches can be used together, can be managed together? It wouldn't be complementary? I mean, ideal types maybe is important to understand the point, the stage of development of a concrete criminal procedure system, and to show the way, the path that we may follow to reach the ideal type of criminal procedure. This is an important point to me because comparative research as well. Thank you, Professor.
Yes, I think that's absolutely the case, and I certainly wouldn't be arguing against that. I think my position is rather that the types of typologies of the ideology that we're using at the moment, that we're so used to reading about in the literature, my question would be whether that is in fact relevant in the current climate, or whether that's in fact been superseded by a number of developments which have taken place in the last, particularly in the last, well, in Europe in the last 20 to 30 years, but we also hear there's been a lot of developments in Chile and other places. So the question is whether these old typologies that we're so used to relying on, whether they have any sort of methodological or theoretical value anymore. That would be the question, specifically inquisitorial, accusatorial, whether this type of characterization really tells us anything at all, whether that can really be of any sort of analytical assistance. And that would be, my argument would not be that we can just look at what's happening on the ground and that would be enough. So my argument would be rather we need to engage more with the realities in order that we can go back and think more about different types of classification, if you like. So I think I would be in total agreement with the point that you were making.
Yes.
Thank you, Sarah, for your presentation. I'm David Caruso from the University of Adelaide in Australia. I just wanted to clarify the point about the content of the advice that you consider should be given around legal aid. Obviously, whether a person is eligible for legal aid has a variety of factors that will attach to that. So if you were able to reform on this particular point, would it be with respect to the police providing better information, or an actual mechanism for someone else to provide better and more complete advice about legal aid options for a defendant?
Thank you. So I've been asked quite a lot about legal reform on the basis of the study that we conducted in Switzerland. To be honest, I wasn't particularly interested in legal reform because the aim of conducting this study was to think, perhaps as the gentleman earlier suggested, was to think then about what that means for normative theorising. But now, because I'm always asked, I've actually had a chance to think about what type of solutions might be possible, because otherwise I just have to sit here and think, So to this concrete problem, one solution might be to offer 3 hours of free legal aid to every single defendant at the beginning of the proceedings. So personally, I don't see police advice as a substitute for legal advice. I don't think that by educating the police or the prosecution that we'll be able to achieve very much, because I see the problems as being essentially structural rather than personal in nature. So for me, my solutions could only be institutional or structural, and that would be a blanket a right to 3 hours of legal aid at the very beginning of the proceedings. It wouldn't be that expensive necessarily. It might even prove more efficient long term. You'd have to measure it, I suppose. But that would remove any sort of discretion. That would ensure that we wouldn't just be paying lip service to concepts such as waiver. I mean, the Strasbourg Court says waiver has to be taken in full understanding of the procedural and legal consequences of that waiver. Well, in the context of my study, I'd be surprised to find 3% of accused persons that are actually waiving their rights with a proper legal and procedural understanding of the consequences of the waiver. So if we're wanting to, if we're going to accept that the approach, for instance, of the European Court of Human Rights on waiver is legitimate, it's correct, then we'd have to radically change our understanding of what that means in criminal proceedings. So I would suggest that would be the only way to, and then at that point, the defense counsel will be able to discuss with the accused whether legal, how necessary legal representation would be in a particular case at issue. But that's not a popular opinion in Switzerland, unsurprisingly. I think we see that across the, I mean, legal aid has just been, is being decimated across the continent. We see it as well, I mean, on the level of the EU, in the initial EU directive on right to counsel, it was originally a directive on right to counsel and legal aid. No surprise then that there was no consensus between the member states on legal aid, and that was chopped out of this directive, and we're just basically left with the restatement of Article 6.3c in the EU provisions, which was very unambitious. And of course, subsequently, there was a directive on legal aid which says basically the member states can do what they want, as I understand it.
Okay, thank you very much. So, Sarah, I would like to thank you for your presentation and thank you for the discussion we had. Thank you, all of you. And I would like to applaud you. Thank you.